Welcome to Adopting Zero Trust, an independent podcast. Our hosts, Elliot Volkman and Neil Dennis, will have transparent and open conversations with the people driving modern security approaches forward, while leaving vendor hype behind. It's time to remove implicit trust and buzzwords and get to the root of the movement.
Hello and welcome back to Adopting Zero Trust, or AZT. Today, we have a wonderful panel to talk about a very timely but a sort of what-if situation. And I say what if because it remains to be seen how the situations that are unfolding are going to impact cybersecurity, regulations, and everything else that wraps around that. However, we do have a fantastic group of folks who can help explore the different aspects of this. And I will reintroduce a couple of folks. I don't have to introduce you to Neil. I hope you know him by now and his
I
voice.
don't know. You did your own little stint there for a while without me. We got it.
Hey, you went on vacation.
I
That's
did
your
go on
fault.
vacation and I left you alone and you did just fine. You did great.
I had to basically bribe people with hats. That's the only form of payment that we have available since we make $0. So just put that out there. Anyways, let's go and start with Ilona. Your background is just insane. Maybe what's the best way to describe? You work over at HackerOne. Everyone should probably be familiar with that brand, but you have a nice history beyond that. So what's the best way to position your background as it relates to this conversation?
Sure, but before we get started, I'm a little disappointed that apparently you bribe people with hats and I don't have one yet. So we're going to have to remedy that.
To be fair, I only got them 6 months ago, and I feel like we had you on a little bit before that.
All right, fair enough. So I'm the Chief Legal and Policy Officer of HackerOne. HackerOne, if for some reason you don't know what that is, we will hack you and try to fix your vulnerabilities before the bad guys do. That's the short version. My background is I've spent over a decade in the government, however, including in the White House counsel's office for the Obama administration. And then I was the General Counsel of the Office of Management and Budget, which, relevant to this discussion, is the agency that handles all rulemaking in the administration. So all the rules that come through.
Perfect. All right. Troy, you're a newcomer to this. What is your background? Who are you? And then I'll actually probably talk about the topic, which will add some more context for why we have this panel.
So I am Troy Fine. I'm the director of SOC and ISO assurance services at Gills Norton. So we are a audit firm, that DBA firm that performs SOC 2, ISO 27001, HIPAA, anything in the compliance alphabet. We're doing those types of services and audit. I've been doing this for probably 12, 13 years, really started my career as an auditor and kind of just built my career on auditing in the cyber world, which is a little different, I think, from other cybersecurity practitioners. But I also post a lot of memes. So if you follow me on LinkedIn, I'm starting to think I might be a better memer than an auditor, but that's still up for debate. But I started to realize that I might try to make a career out of that. We'll see.
That is true. That's in fact why I was trying to build a podcast around you. Certainly 40,000 people can't just care about your memes. They got to care about your opinions, or maybe it only is in meme form and
opinions,
like motion graphics.
Opinions are hard. Memes are easy. So I try to stick to the memes.
All right. Totally fair. So that brings us to the topic of today, which is, again, very timely. It could change by time we actually hit publish on this thing. So just fair warning. I'm not going to say the exact date because then I will get in trouble for something else that I currently do on the side. We're not going on that topic, though. Anyways, so we're going to be talking about the recent Supreme Court overturning of the Chevron Deference, which is, I don't want to try to explain this. We have an expert for this. I'm handing this over to you. Maybe you can contextualize this, and then the rest of us can ask a couple of idiotic questions to bring it back to reality.
Sure. Happy to try. So at the end of the Supreme Court's term, there were a couple of opinions actually that overturned a bedrock legal doctrine known as Chevron Deference. And what the Supreme Court held was that courts could no longer give deference to federal agencies' interpretations of federal statutes. So under the Chevron doctrine, before these cases, which has been in place since 1984, courts would defer to federal agencies' interpretations of the ambiguous statutes as long as those interpretations were reasonable. So that is no longer the case. Now it's to each court to read the statute anew and make a determination about what whether the agency's interpretation is the best interpretation. And I know that this says, on the headline, AZT Chevron Deference, but I would also like to mention that there was another case that is just as important as Chevron, and that you have to look at the two together to really get a full understanding of the impact of the court's action. And that is the Corner Post case. And so that is important because until that case, there had been an understanding that companies or plaintiffs had up to 6 years after a rule was finalized to be able to challenge that rule. And that was always understood to be 6 years after the rule was complete. And now the Supreme Court has said, no, it's 6 years after the injury has been discovered. So this puts basically every federal regulation on the potential chopping block.
Yeah, just a few potential impacts for our space. Yeah, not to mention there's still a lot of things that we're currently in, but maybe we can start with the big hot topic, which is AI. So there was a headline probably just this week, or let's say middle of July is the safe way to label that, of the other administration, which may or may not make it in, to basically pull out all the stops and make AI regulation a little more friendly towards US. And I think that's how the EU AI Act is their stuff. But that is just one aspect of things that we're already hearing about so right now, there is no federal AI regulation, correct me if I'm wrong, but there's 40 bills in the works. There's a pipeline where there could be some impact. I'm curious from your perspective, like from all the things that are in the works today, how do you feel that some of that could impact, especially on the cybersecurity front, where people are abusing it for increased social engineering and kind of ransomware building and malware and some of that stuff? Do you have any visibility into how you feel like pulling out the stops could increase risk or something to that extent?
Sure. So following the ruling, the conventional wisdom, or the set of rulings, following the set of rulings, the conventional wisdom is there's going to be a lot more challenges to all rulemaking going forward and a lot of regulatory uncertainty. And that's in part because there aren't that many clear rules or clear statute on either cybersecurity really or AI. You're right that there are a lot of pending bills right now. So there's potential for future law, but Congress doesn't move very quickly, as I'm sure everyone on this call knows. They move very slowly. And even when they do move, they don't actually have the capacity to necessarily prescribe a certain set of standards that will keep pace with technology. So no matter what, anytime an agency has to interpret a law in order to make a relevant and a timely rule, they're going to have to rely on something that's ambiguous. And then that just means that's going to be more and more likely to challenge. The outcome is not necessarily good for business because although there are many business organizations that applauded this set of rulings, the reality is the uncertainty when it comes to regulation could in fact be very bad for business. Companies rely on the fact that they understand what the regulatory outcome is and they can plan for it. And in this case, you're going to see something very different. You're going to see uncertainty when it comes to the existing set of rules, but you're also going to see uncertainty when it comes to future rules. So it's going to be very challenging. And this is actually something, AI in particular, something that came up in the oral arguments when the Supreme Court considered this. Justice Kagan mentioned AI, and she talked about the fact that might be something that courts really might not get right because they don't have the expertise necessary to be able to really make a decision about how the statute should be interpreted. That you need to be able to rely on the agency experts who have the more of the scientific expertise or technical expertise necessary to be able to promulgate the rule.
Okay, so that certainly makes sense. If I was to summarize that, we're entering a state of significant increased uncertainty, which means both positive and negatives can come from that. There's more gray area for people to explore things, but without the guardrails that are being put up elsewhere, it could create some other scenarios. Neil, I'm going to maybe throw that over to you a little bit. Feel free to jump on a soapbox because, I don't know, there might be something there, right? With the framing of, yes, we know that even on the federal side, probably not cybersecurity experts, let alone AI experts. Yeah. What are your thoughts?
I had a initial quick curiosity question before we go down the AI particular rabbit hole. At a high level, does this impact the federal government's ability to push things down to the state level, or does this give more power to the state level to impact regulatory things like this in their own boundaries? So there's a point behind that when we get there. I'm just curious, does this empower the states a little bit more potentially, or possibly push more requirements down onto the states to have their own guidelines for stuff, AI or other things of that nature?
I think it's the way I see it, this uncertainty at the federal level may prompt states to act in a faster or with greater breadth than they might have otherwise. And that also creates a problem for industry because all of us who are trying to deal with privacy law, for example, understand you have to deal with California, and that's different than Illinois, and that's different than New York. Each one of these states has a different set of standards, which makes it really difficult for industry to try to comply with the differing views of the state lawmakers, and that it's sometimes better for the federal government to act. But here, when the federal government is going to be potentially in a state of turmoil, it might prompt faster action from the states.
So that makes sense to me. So the reason why I ask is because we've started down it a little bit. When we think about AI regulation or privacy regulations, or in the state of Texas at the moment, this is a big thing here, where they're enforcing privacy regulations around the adult entertainment side of the house. There's things that they're putting into play that are impacting that, which is living 2 minutes away from Austin. They've literally picketed the crap out of that, which is hilarious. But different topic, different podcast. So I asked because at the state level,
I'm not on the podcast. Don't invite me,
Not
please.
mine. But the reason why I'm curious about it is because the state is also, Texas as a state, I think has a little bit more impactful cyber regulation, forward thinking or negative, either way you want to look at it, whichever aspects. They do a lot of really neat things from the cyber world. They do a lot of weird things that are just annoying from regulation. So when we think about AI, because now, as everybody knows, we have SpaceX and Twitter formally being relocated here, and Elon's position on AI regulation, all the other stuff, what it is. So back on AI, I'm just more curious about if that seems like a technology that could be impacted at these regional levels while we wait for the federal government to do things. I feel like AI as a construct and security is too much of a global thing for a state to really try to wrap something around without it being hardcore challenged every day of the week. But that's what my personal fear is. And so I'm just curious, federal regulation versus state regulation around things that seem a little more global, impactful, especially the AI topic.
I do think you will have other bodies, like international bodies, state bodies that are going to act in the face of uncertainty at the federal level. I do think the federal government is going to try to legislate. But as they move so slowly, and whatever they come up with in the federal front in legislation is going to need the interpretation of the experts at the agencies. And that subsequent interpretation and application to real life standards, real life circumstances, that's what's going to be really under the gun here when we're talking about the post-Chevron world. There are a couple of things, not just in AI, but also in cyber, like CIRCIA, the Cyber Incident Reporting for Critical Infrastructure Act, which is currently a proposed rule. Now there are other similar critical infrastructure rules that are coming up as well that are trying to impose cyber standards using laws that never even dreamed of the word cyber, let alone regulating it, that are all going to come under the gun and are going to be subject to a lot of scrutiny in the courts. And not only are we going to have to rely on judges who may not know the first thing about these topics, you're also going to have different judges in different jurisdictions reaching different opinions, which is going to lead to, I'm not going to say a state of chaos, but certainly uncertainty that's going to make it very difficult for companies to know where to invest and how to make sure that they're actually going to comply with what ultimately becomes the standard.
I could definitely see a lot of escalations going unanswered towards the top of the food chain just because of the scale of how many will probably happen. You talked
Neil,
about...
let me derail you for a second. Troy,
No.
you deal with these
Yeah.
all the time. Yeah. I'm curious from like the auditor perspective, how do you untangle that when you have folks that are coming to y'all for whatever perspective, they have overlapping stuff? Like, is there a standard talk track? Like, how do you untangle the 30 different overlapping things and whatnot?
That's the short answer. I think, I don't think you can, especially when it comes to privacy, right? As we were talking about before, with all the state laws. If you're a global company, you have to deal with country-specific privacy laws. So it's not just in the US. It could be all over the world, right? There is no, you can't, right? If you look at Meta, look at Google, they have privacy teams, but like they have budgets for dealing with privacy violation. They're budgeting for that because they know it's impossible to do it. And you're going to spend more money trying to comply than you are probably paying the bills to the governments, right? I don't think you really can. I think you can only do your best effort and hope you're not doing anything negligent that would cause somebody to take a closer look. And that's what they try to do. So
I was just thinking, like, going back to some of the questioning, like, think about what Congress or the courts would do with something like quantum computing, right? There's rulemaking that's expected. And do we really think that Congress is going to get that if they do it in such a prescriptive way that will be without ambiguity, therefore without legal challenge? And even if they do, we think that the courts are going to be able to interpret whether or not the agencies get that. I'm not suggesting that the agencies should be without any checks on their authority in some of these areas, because we want rules that are fair and not burdensome and not overly cumbersome for industry and that are tailored really narrowly. But on some of these more complex challenges, like in the technology realm, AI, cyber, like I mentioned, quantum computing, do we really think that the courts can get it right? And this is again where Justice Kagan's dissent, writing for the minority, said this opinion took a rule that was based on judicial humility and turned it into one that was based on judicial hubris, suggesting that the court really thinks it can do no wrong. It will be the best position to decide all of these things.
Well,
and I
would
really
say,
do
too,
question.
They can't. It's impossible because of the rate of change, right? You can't write a law that can, in technology or cyber or quantum, whatever you want to call it, it changes too fast to have a law that covers it all. 5 years from now, it can be completely different.
6 months from now, it's going to be completely different.
And I think maybe that's, for me personally, I think maybe that's the pro to this, is indirectly, just by sheer volume, deregulating things that, and this is the libertarian side of the conversation, saying that federal overreach on things that weren't clearly defined constitutionally, blah, 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 blah. Everybody pick your political party, figure out what you want to talk about there. But I see potential, especially in the tech world, where 90s, early 2000s, Wild West, in the grand scheme of things, you had hackers, crackers, white hats, black hats, pick a flavor of the day, doing all sorts of things and not really having a lot of legal structure to put them into prison or to do things when they were blatantly being malicious. Until the court hearings back in 2007 or 8, whatever it was, when the gentleman in Austin went to jail for the first ever spam abuse case. Big thing, fun stuff. I lived down the road from him when it was happening. It was fun to watch them roll him up. I didn't know what was going on. But that set precedents for what it meant to be a spammer and take up internet bandwidth. So they wrote legal structure of some sort around him to arrest him post his arrest to capture other people like him. I like the Wild West in the tech. A lot of fun things get done personally. Yes, I still need to know who to arrest and throw in jail. But when it comes to developing tech, I think personally, less regulation equals better innovation down the road. You throw some guidelines on it relative to what it means to do so maliciously. But I think they still need to be a little more open-ended, especially when the tech is just getting there. I like the approach of the movie theaters and the music industry of self-regulation. And as long as you do it correctly, then the government should have no need to come in and slap you around and tell you what to do. That's my personal.
So there's one, first of all, I don't think of this as a political issue. I know that you just mentioned politics. I think of this as just an understanding of how you view the world. But there's one assumption that you made in your statement that I think is false. And that is that less regulation means less burden on business. And I actually think in the absence of rulemaking and the challenges associated with rulemaking, you will not see agency in action. You might see more agency enforcement action. So different form of action. It will depend on the agency that you're talking about and their authorities and how they use those authorities. And I'm not suggesting even that those would be without any challenges. But the difference is you've got in rulemaking, you've got an agency telling you in advance, actually not you, telling everyone in advance how they perceive this statute and its interpretation of the statute before you act. Whereas agency enforcement action, you only see that to a single party or a set of parties after you've already acted. And that's why I prefer that as an industry representative, I would rather know in advance how the agency perceives something, how they view the interpretation of a particular statute before action rather than after action. I don't necessarily agree that less regulation means less burden.
I definitely agree with that. I don't agree with that side. So I apologize if that's how it came up. I think burden of labor and burden of proof, all that fun stuff falls on the private side, whoever is managing, developing, running XYZ technology, until the agency does step in and say, we think something's wrong. I think, once again, back to the old internet, that's loosely what happened initially. We had people early 90s, 80s, early 90s doing all sorts of stuff, positive and negative. No regulation blatantly there. So we had to rely on, in the early 2000s, on someone like Time Warner to say, you're going against our personal business bylaws for usage and access. And that's what they wrote him up on. Was one of the big things was he was using someone else's Wi-Fi along with his own, and they just put him in court initially for some kind of bandwidth stuff and illegal usage of Wi-Fi for private guidelines, whatever it was. And then they wrote other laws about the consumption and tier 1 ISP utilization rates and all this other stuff for him. And I personally like that. But I think it's on the persons doing the work to understand where they could potentially go wrong, and the industry that's doing the work to initially self-regulate until they reach a boiling point where the agencies come in and say, hey, WTF, you're doing some things that we don't necessarily agree with anymore. And then let's duke it out in the courts. And maybe that's how the law comes into existence. I don't know. But I like self-regulation at the industry layer as a starting point.
What about critical infrastructure? Take critical infrastructure and take some of the impacts of critical infrastructure's lack of cybersecurity adherence, cybersecurity regulation, or self-regulation, right? There are times when failure to adhere to basic cyber hygiene leads to entire sections of our economy shutting down. Colonial Pipeline is, of course, what I'm thinking about. And that impacts not just the industry, not just the company, but an entire region and an entire economy. And so that is the basis for the Cybersecurity National Action Plan and this administration saying, we need to level the playing field. And if you're not going to get there yourself, we're going to read these statutes creatively in order to make sure that you do protect not just yourselves, but all of us. So I'm curious. I know you're the podcast host, not me, but I'm going to turn it back on you and say, I'm curious, do you think that those companies that have completely ignored cyber to the detriment of an entire economy should just be able to continue to proceed as normal? Like,
No, I think
Eastern Seaboard be damned. I'm just going to do what I'm going to do.
No, I think so. That's a very valid question. So I think in that case, we already had two, both federal and private regulation bodies that were at play, and they ignored both. So I think under a private industry perspective, the hilarity was that Colonial Pipeline definitely had some issues in the private sector of things with their cohorts and their partner services and things like that. We'll leave it at that verbally, but they obviously had issues there. So they were paying the penalties before they even went before the federal courts, once all this happened, with their private sector partners. And I think that's very important as an initial base. They did something wrong. The private sector of that, those other businesses that they were with and doing things with, regulated them as much as they could at the time when that was happening, and more or less impacted the prolonged business once things were back up and running financially. And then the federal courts came in and saw obviously what had happened, saw what was going on. And I think that was a good teeter moment to make a new regulation and law for how that happened. And yeah, I think you're going to have key turning points like that lead us down the road where government oversight should be applied, or a review of what current oversight is there and where you missed the bill from the private regulations that your industry vertical may or may not have had. And so, yeah, I think it's a very fair question. And I think that is one of those milestone moments where someone needs to get smacked in the face, and then government oversight can review what's already been going on. But absence of...
Prince, is that courts are no longer really able to defer to a federal agency who makes a calculation based on common sense, right? The agency is generally supposed to come up with a reasonable interpretation. And it might be reasonable from my perspective, from your perspective, to finally get to some kind of a regulation that would prevent another colonial pipeline from happening. But that's not the calculus anymore. That's no longer
just to
the
clarify,
standard.
are you saying because this was, that like the TSA is the ones that oversee the pipelines, they interpreted a law based on this doctrine, they come up with rules. Are you saying that they wouldn't be able to do that anymore because of that? Or
Well, look, I have not specifically looked at that rule to assess whether or not they would have the authority to be able to move forward, whether they relied on a reasonable interpretation or whether they relied on the best reading of the statute. But I'm just saying generally, Neil is having an argument with me, or discussion, I should say, about whether rules are good or not, whether regulation is, when is the right time for regulation. That's like the discussion that we were just having. And I'm saying you can't really apply common sense anymore to when is the right time to have a regulation. Because even though you and I might agree that it's time because there's such a significant impact, it's really all about the statutory construction and whether or not the statutory construction is the best. And in light of the fact that most of this administration's effort to level the playing field when it comes to critical infrastructure and cybersecurity standards for critical infrastructure, those are based on old laws that very likely talk about safety more generically than cybersecurity safety. And so you could easily see a court ultimately invalidating those. It's just something to think about. I think that's our new reality. And that is
I think
concerning.
you're right on the safety things. I know the FTC brings they find a lot of companies based on old rules that just talk about safety, and they're interpreting safety as being cybersecurity related, which the law might have been written 50 over 100 years. Could have been written 50 years ago and talked about safety, but the FTC is using this to say you didn't have the right cybersecurity protections in place. They're now finding you blah, 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 or they're using it for privacy. So I think you're right. I do think it's going to impact cyber from that perspective, because how could you say that safety, when they wrote that law, they didn't even know cybersecurity was a word. right? And now you're interpreting it to include cyber. I could see them saying that's not allowed anymore, for sure.
Sure. Yeah, that's not always a bad thing, right? Yesterday, the court threw out most of the SolarWinds case, and they did it in part because they said as a matter of statutory construction, the way that SEC was interpreting its authority was wrong. So they used a law about internal accounting and disclosure controls to apply to controls relating to cybersecurity. And the court said, no, that's not what the statute says. So you don't have that authority. And I'm not sure if that had been decided before the Supreme Court decisions, I'm not sure it would have had the same outcome. So, like I said, it's not always a bad thing. I didn't look at the facts of that case well enough to know if that was a good thing or a bad thing. But the bottom line is there will be times when agencies completely get it wrong. And so there is a role for the courts there. But I do worry that most of the time they're not going to get the technical stuff right. And they're not going to get the sort of scope and breadth of the rule and its application. They're not going to be able to apply common.
So I think on those point in time, and actually write a new regulation, new law, new rule based off of current issues, concerns, and see how that goes at some level. I think for me, that's the big thing. Instead of using 50-year-old policies to interpret things, define or debilitate or grow, either way, it goes both ways. Industry verticals, making sure we have blatant, as best practice as we can, regulation, and understanding it's going to change in 5 years, the technology behind it. But the fundamental compliance pieces or the fundamental security nature of it, the tech targeting it changes, but the construct around cybersecurity and the things that you're expected to secure, like zero trust environment and methodology and things like that, are a little less fluid, right? From a higher level strategic terminology perspective. And so I think back on those, I think that's for me the big thing. When we leave it open to the agency to interpret, we have someone who's more likely to get fined or brought up on charges and spend time in court for something that doesn't make as much sense. And I'm not a lawyer, so this is all just me hoping to never go to court for stuff that I think I did. Statute of limitations is up on most of the stuff I did that was bad, so we're good. But that being said,
I can refer you to someone if you need it.
I might. I have confessed to way too much crap on this podcast over the last 2 years, but nobody's knocked on my door again, so we're good. But that being said, I think there's a time for regulation. I think back on the critical infrastructure key resources side of the house, if you're a large enough persona in something that's already been defined as CIKR stuff, you already should be expected to have some kind of regulatory requirements, both from your direct industry vertical as well as the government. And I think that's a fair assessment to say within those echelons, congratulations, you've got federal oversight. For the rest of the things that haven't been defined, back on AI and quantum computing and things like that, for the time being, I don't see a world where at the start of the technology, federal oversight is necessarily a great thing until we have some kind of milestone landslide moment that does push something bad to say, wow, you definitely stepped outside your bounds. Congratulations. This was rated whatever. You need to be put up on something, right? So that's kind of my take. I think if you get into critical industry, key resource stuff, and those, clearly defined what they are, you should have expectations for that, like Colonial Pipeline once again. But if you're outside of those verticals, I think less regulation until you have a milestone issue is better, like SolarWinds, as an example, and what they had to do. But I'm just curious, back on questioning side of the house, we'll go back and forth with our personal views all day long. Not a bad thing. We should just have a podcast where we literally just get the most divisive topic and get 3-4 people in a room. I don't care what it is.
We'll just take Neil's view and say, this is the new standard that the courts have to apply. Whatever he thinks is right and is appropriate for federal regulation shall be regulated. And whatever. is not appropriate, according to Neil, shall not. Is that, I think, what we should do?
The whole world will go to pot. I will say the one thing recently that happened here in Texas, federal judge struck down the private distillation licensing requirements by the federal government. So I make wine part-time, so this is exciting, but it might actually be this wine I'm talking about because I think it's indirectly related to this because they just made the announcement like this week that the federal government, ATF, is only allowed to apply regulation for licensing for stills to actual production commercial facilities, and that the home production of any alcohol should be non-regulated to the confines of the quantity that they allow, to include distilled spirits or something like that. Anyway, that's exciting for me. But on that note, from a compliance perspective, again, moving forward, I was very curious back on GDPR type things, and we touched this at the beginning. When we think about state empowerment to do these things, do y'all see maybe where with California's privacy laws and the ones that are happening in Texas and a few other places, do y'all see those as possibly moments in time that could push federal regulation a little farther, whether that's zero trust compliance, whatever it may be? But do y'all see that more of a grassroots movement at a state level being able to help guide federal rulings and structure and law versus waiting for the federal government to do things again?
I think the biggest impact, I don't know, Troy, you can answer because you have to comply with these laws, but just one quick answer for me is that the biggest issues for some of these companies is not in the United States, it's in the EU because they're moving so much faster than everybody else. So for a multinational company, they are obsessed, focused on what they have to do to comply with the laws that are so far ahead of us. And that, if anything, I think would push the US more than some of these states, given the breadth of the law.
I would agree. I don't think the states are really going to push the federal government to do anything. If you look at the EU, there was a time recently where there was a lot of people didn't want to send data over to the US because we weren't like, whatever, I can't remember the terminology. We weren't officially approved by the EU to like GDPR to send data across the Atlantic to us until we came up with the new data, the DPA, or the new agreement, and then they were allowed to all of a sudden. A quick fix. But that is what's going to drive the US to come up with a federal privacy law. Businesses can't be global and can't do things because certain countries don't want to send data to the US or too problematic for them to work with the EU. That's what's going to drive the US to change, unless they can come up with a quick fix like they did and solve the problem. We were close. We were getting there. And then they did this quick fix. And now it became a domestic bipartisan issue why we don't have a federal privacy law. And that's probably not going to happen anytime soon.
Oh my goodness. There's so many reasons we don't have a federal privacy law. That's a whole other podcast that we could do for hours.
I'll be on that one.
Yeah. The EU really is moving quickly, especially when it comes to AI. Like the EU AI Act for sure is the focus of so many different companies. I'm not sure you will ever see those large companies deal with self-regulation because what they'll be doing is dealing with another country's or body's legislation or law, and that will force them to make changes in the US regardless of whether the US acts.
So thinking about that a little bit more, if we get to a point where we have some kind of formalized federal policy on this, do y'all think it's going to be a very cut and dry, or do you see things like California versus other states or whatever challenging this for years to come kind of thing, courtesy of the new rulings for Chevron and written up? And
there is no federal privacy law. I don't think there ever will be a federal privacy law in my lifetime. Maybe that's a little bit too much of an overstatement, especially given that there was an attempt this time around with Congress introducing the bipartisan privacy framework. But we all saw what happened to that. It died a slow death, or actually it died a pretty quick death, to be honest.
Yeah, there's not going to be
question. Troy, would you be fine if there was one?
Yeah. Probably not like a GDPR. There are privacy laws, right, that protect children and other stuff like that exists. But I'm not an expert enough to know how this would impact those types of laws. But I agree. A comprehensive one like GDPR, probably not. We need to start off small Like we need basic protections at the federal level instead of trying to go all in on everything GDPR does, maybe like basic rights to be forgotten and things like that. We could start off small at the federal level, but we don't normally, we try to run in the US government before we don't do the crawl, walk, run. We just run sometimes. And that's what's happening with privacy. They need to slow it down a little bit and get like the most foundational things. Hey, we all agree you should have a right to be forgotten if you tell someone. Okay, let's get that in the law. Yeah, it'll probably be never before that happens. So, yeah.
But this is, in my view, this has less, the discussion today about Chevron Deference is about agencies interpreting an existing law. And we're saying on privacy, there is no existing law and it'll be really hard for Congress to come up with one. Another reason why, curbing an agency's ability to act is going to have consequences because Congress does not act with expediency, as we know, and they don't act with expertise necessary to make informed judgments always. So that's suboptimal, and it's going to lead to a suboptimal outcome.
So one last question from me back on that. We'll go with Troy first and then close up Ilona there. Curiosity question, and you hinted around this a little bit. What is summarization of worst case scenario for this ruling, best case scenario from y'all's perspectives? And we hit on this a little bit throughout, but I'm just curious, quick summarization, worst case, best case for you, Troy, worst case, best case.
I don't know if I can answer worst case, but best case for me would be that it actually accelerates the government to come out with cybersecurity regulations that are specific to cyber, right? Going back to the pipeline, instead of them having to interpret a old law to come up with new requirements or pipelines to protect data, they should come out with a cybersecurity regulation where they don't have to interpret, or there'll always be interpretations. But interpret less, right? Not have to use the word safety to mean cybersecurity, right? So best case is that accelerates some of these things that are not in place. That would be best case for me. Accelerate, I'm saying at the government's pace, whatever that means, right? Like instead of 5 years, it happens in 2 years. I don't know. But to me, that would be best case as a positive outcome, maybe from something like this. But yeah, worst case, I don't know how to answer that because I don't know what the implications could be. I'm just on my area of expertise.
Worst case, you get 50 states doing 50 different things? No.
Best case is that Congress can fix this. So not a done deal in that Congress can delegate discretionary authority to an agency. So they could tell in a future statute, they can say, and in the interpretation of the statute, we want this agency to have the final authority. And that's that. And then this is not an issue and the agency can rely on its expertise and continue to go on as always. I don't know if that's the best case. Like the best case is always tailored regulations, not burdensome, cumbersome, like actually helpful to the economy, helpful to the security and the well-being of all Americans. That's the best case generally always. But in terms of this precise issue, this can be solved by Congress. I don't see that happening anytime soon, by the way. It can. The worst case is, as we've discussed at length during this session, a lot of uncertainty, differing opinions, different rulings, companies not knowing what to do, sinking a ton of money into trying to understand how Texas rules on something versus how New York rules on something. And then courts not being able to have the ability to issue an opinion that actually is a common sense one. Yeah. So it's hard to know what rules will come before these courts now without looking into all the different statutes. But you can imagine a circumstance where common sense is just not allowed to prevail in light of the restrictions now on the court.
And I will agree on that last point. That is a concern. Whenever the rule finally has to be addressed, changed, adjudicated, wherever it goes in the court, I'm right there with you on the worrisome of the quality of that court and their ability to understand whatever that stuff is. That is a big concern. So I appreciate it. I'm going to throw it back over to Elliot because I definitely went down some oddities there. So I appreciate it. But I'll leave it with this. If either of y'all want to help me interpret the distiller ruling here in Texas, I'd appreciate that because I own one, but I would love to own one and be able to blatantly say I own one without the federal government doing what they did here and calling up the club that was distilling stuff. So I would love help with that later. But anyway, moving over back to Elliot.
Just don't blow yourself up or anything. Otherwise, I have to cancel the show, and I don't know how to handle that one.
I still have all my fingers mostly from the 4th of July, so we're good.
I don't know. I would help, but my legal advice is generally worth a little bit more than a hat, and I didn't even get it. So I'm going to pass on the additional invitation to provide free legal advice.
God, Elliot, look what you're doing to me, man.
We just have to make these a rare batch, start auctioning them off, and then it'll equate to something.
I want to also go on record as saying
both of us have to blow up at your production facility.
Yeah. I want to also iterate, Elliot's the producer. I'm just cast. I'm not even crew.
I literally just press the mute button on myself while I laugh. That's my job. But I do have one question. I feel like, Neil, this is into your waters for like self-regulation, but it's a dance between BS and not BS. And that's where we get to these concepts of privacy by design, secure by design, shift left, and some of these other things of like self-regulation. There are not hard guardrails that you have to follow. It's these concepts that are like doing the right thing because it's a differentiator and all that. Panel, what are our thoughts on that? Do we feel like that will, let's say we devolve into chaos with these situations and things just unravel? Do we feel like there's going to be organizations that stand to the occasion and start aligning more with these things to do the right thing? What are our perspectives on that?
I have a view, but I want to ask Troy to answer first because I feel like
it already is the Wild West. Look at
fair.
Look at United Health Group, right? That caused mass problem. It happens probably once every 4 months. There's a major thing going on that's causing problems. Not all cyber related, but CDK, same thing. Dealerships were reporting that they were actually, their financials were impacted for the quarter ending June 30th. They were actually reporting that because of the outages. They couldn't make their sales. So we already are in chaos and we're just trying to figure out how to live in the chaos right now. So I think it's only going to get more chaotic based on what we just discussed, to be honest. But
yeah, I agree with that. There are some industries that are better equipped to self-regulate than others. So take the payment card industry. They have a robust industry association that has imposed real regulation, real standards that everyone complies with because they want to be able to offer payment services. But that takes a long time to get to that point. And the process is really messy. And so now, for example, in AI, you have, in the absence of a national standard or even a state standard, you've got companies trying to impose what they're calling responsible AI. So they're trying to come up with their own version of what that means. And it's all over the map. And so you've got companies now through contractual requirement imposing things like definitions of responsible AI and other companies having to comply with multiple different versions of what that means. And that is messy and it's timely and it's expensive and it's hard to track. And so that's why sometimes a national or even state standard can be useful because it reduces the cost to comply. So the answer, very long answer, is it depends.
Yeah. Inception as well as at its growth points to where it's at. Again, back to critical industry, key resource related stuff. On your anecdote, there's another comparable piece for advertising on the internet. There's a large company or large group called TAG, Trust and Accountability Group. They are there specifically to regulate what it means to be a media content provider in the advertising world on the internet. And they started off as a very fledgling foundation, like any good thing, sitting up in DC on the Hill, trying to get their pundits together. And now they own the regulation as a private industry group for how to appropriately put things through content delivery providers and stuff like that on the internet. And it started off as a US based thing, but it's a global impact regulatory body, private regulatory body now. So then it did, like with everything else, it did take them time. They were born semi out of the inception of some of the stuff in the mid 2000s, where a lot of threat actors were leveraging CDNs to push a lot of not so good things. So they had their little kind of come hither moment there, their milestone moment to push them over the edge. And here they are, self-regulatory body. And I think that's probably what helped keep the government out of those worlds and keep the Googles and Microsofts safe, but in a private trust group mentality. But to your point, that's not always going to happen. I agree that is not always going to happen. And in absence of that happening, especially in a timely fashion, when you have a breakdown, unfortunately, you're going to get slapped legally somewhere, and someone's going to have to create a rule to make sure it doesn't happen elsewhere. So bust your butts off to make some kind of private regulatory landmark for your group. And if it sticks, and self-regulate. If it doesn't, congratulations, you're in the Supreme Court. So at least yeah.
And that takes us to the end of the episode. So Ilona, Troy, thank you so much for joining. Neil, so glad you're back so I don't have to talk to the wall. We will see y'all next time. And yeah, we're hopefully off a little hiatus for summer, but otherwise expect back to our every other week publishing schedule.
Are you putting this out before Black Hat?
I don't know. Hopefully.
See you at Black Hat if he gets this out in time.
Oh, yeah. We're going to be at Black Hat, I think. Find us somewhere. We'll figure it out.
Thank you for joining AZT, an independent series. Your hosts have been Elliot Volkman and Neil Dennis. To learn more about Zero Trust, go to adoptingzerotrust.com, subscribe to our newsletter, or join our Slack community. Viewpoints expressed during the show do not reflect the brands, employers, or companies of our hosts, guests, or potential sponsors.